Imagine you certify compliance with civil rights laws as part of a government grant or contract, your company's ESG initiatives or something else. The DOJ now comes in. It says it's going to use the False Claims Act to pursue anyone knowingly violating civil rights laws while receiving federal funds. That's the Civil Rights Frauds Initiative it launched on May 19, 2025, and pharma and medical device companies need to be worried. These companies rely on federal funding, collaborations, R&D grants, or Medicare Medicaid billing, and this raises urgent questions. So today we're unpacking the DOJ's Civil Rights Fraud Initiative around diversity, equity, and inclusion, and what it means for your compliance programs. Hi, I'm Darshan Kulkarni on DarshanTalks, part of the Kulkarni Law Firm's Deep Dive program. If you work in pharma or medical devices, please hit subscribe so you don't miss critical updates. Let me ask you this. Have you reviewed your DEI or related policies recently with your legal team? Do you feel confident that they can withstand a DOJ review? Think about that as we go on, and feel free to share your experience or concerns in comments or in feedback. First, why is the DOJ actually focused here? Under the new Trump administration leadership, the DOJ wants to enforce equal protection vigorously, and it sees the False Claims Act as a tool against fraud when recipients of federal funds violate civil rights laws. So if you certify compliance but knowingly maintain discriminatory policies, perhaps DEI programs that assign benefits or burdens by race or similar traits, the DOJ might see that as a false claim. Now, ideally, the DEI programs and the efforts aim to correct past inequities. Some programs risk crossing legal lines. The memo cites Title VI, Title IX, and related law. Eliminating racial discrimination means eliminating all of it. So, even well-intentioned policies will get scrutinized. For pharma and medical device companies, you often partner with universities with research sites or offer patient assistance programs partially funded by federal dollars. Any policy that treats individuals differently based on protected traits must be carefully vetted. So suppose there's an RFP or a grant application that says, we ensure equitable access through targeted outreach. But these outreach criteria inadvertently impose race-based burdens or benefits, and this could draw questions. Council must map out where civil rights laws intersect with operations.
Enjoying our content? We'd love to hear more. Please like, comment, share, and find more.
Now, let's update your compliance playbook. Let's start by audit certifications and policies. You want to inventory every federal funding or contract that requires civil rights compliance attestation. You want to review your DEI initiatives, your sponsorships, or your partnerships that include race and gender-based criteria. Identify anything that could be seen as assigning benefits or burdens based on protected traits. Check training materials, supplier diversity programs, hiring or promotion practices if they're tied to government contracts. Then you want to look at your risk assessment and documentation. Document your analysis. Show how your programs align with permissible goals and avoid unlawful distinctions. If you retain consultants or outside experts for DEI strategy, have them provide legal memos. For every program, ask, could this be challenged as a violation of Title VI, Title IX, or another civil rights law? And keep that written rationale. Then you want to have a compliance attestation process. So you want to strengthen approval workflows before any new DEI-related initiative. Run it through legal review, specifically considering the memo's warnings. For existing certifications, avoid boilerplate language that overstays compliance. Where necessary, include qualifiers or disclaimers reflecting any limitations. Think about your training. Train compliance, HR, and business teams on the memo's implications. Explain False Claims Act risk. Treble damages plus penalties. Emphasize the seriousness. Use realistic examples. So think about patient assistance programs, think about how supplier diversity is tied to federal grants, and talk about clinical trial recruitment and those diversity action plans. Next up, you want to engage stakeholders early. Work with grants teams, procurement, HR, and diversity offices to align on lawful objectives. Focus on inclusive policies based on permissible factors like socioeconomic need, geographic access, or universal criteria rather than race alone. If you're targeting historically underserved communities, you want to frame your initiatives around eligibility criteria grounded in objective needs like income thresholds, rather than race or ethnicity.
Find related podcasts below.
Then you want to monitor developments. Watch for enforcement actions or guidance from the DOJ or OMB. The memo references coordination with agencies like HHS and Education. Stay alert for whistleblower lawsuits. The DOJ is encouraging reporting under the False Claims Act for civil rights violations. Ensure that internal reporting channels are robust. You want to prepare a response plan. If an inquiry arrives, have a rapid response team, legal, compliance, subject matter experts. Document all prior analyses and decisions to demonstrate good faith. Call, click, or email